we hope that we actually get something, but if we don't, and we again get sort of flimsy reasons, then that's what we're going to take to court to say, well, after 2 years, they still have nothing to prove that the state of disaster is necessary to cope with COVID-19 and to effectively protect South Africans.
Civil society groups AfriForum and DearSA have launched a joint application to end the state of disaster. Joining me to discuss is the attorney for both parties, Daniël Eloff. Daniel, always good to have you here. Could you tell our viewers what are the details of this application that you've launched against Minister Dlamini Zuma?
Thanks, David. In a nutshell, we're basically hoping to end the entire national state of disaster that's been declared for almost 2 years now. I remember, I think it was in October of 2020, that was the first time I came onto this channel to speak about the lockdown and the state of disaster. And here we are nearly 2 years later, and we're still discussing it. And I think that sort of illustrates the need for why this case needs to happen and why it needs to be heard and why the lockdown needs to be ended. I mean, we can't be in this perpetual state of a state of disaster, particularly if you consider that the circumstances that were there in March of 2020 no longer exist, right? We have effective vaccines. We know how to deal with this virus. We even have good treatment options. So we've learned quite a lot about COVID. We learned how to deal with it. And frankly, South Africa should sort of follow the rest of the world's example and move away from this lockdown approach that we've seen in the past 2 years.
All right, so take us through the legal process, because there are various stages to it. Where are we now, and what are the phases that are coming down the pipeline?
Sure. So this case that we brought is not an urgent application. So it's not one of those instances where we announce the court case and in a couple of weeks we're in court and there you sort of battle it out. We took the longer view with this case and we brought the case in the normal course. So at first we started our application at the beginning of this year. So the Minister of COGTA was supposed to file her record of decision by the beginning of March, but she failed to do so. And they wrote to us and said, can they please get an extension until the end of this month? So we're expecting the record by the 25th. After we then receive the record, which is supposed to contain the reasons and the supporting evidence on why she's extended the state of disaster and why she's keeping it in place, after we receive that, we then get the opportunity to supplement our court papers based on whatever we receive. And then the Minister of COGTA gets the opportunity to file her answering affidavit. And then we're basically ready to go to court after we file a reply in response to her answering affidavit. So we're looking at a court date around the middle of this year. And hopefully we can get there soon. And we hope to keep the minister to a promise to file the record of decision by the 25th, because what we suspect is that there isn't really a record of decision. They don't have supporting evidence and documents and expert reports to rely on. And that's why they've sort of played for this delay. Our other consideration was that potentially she asked for an extension until the 25th of March because she wasn't going to extend the state of disaster. But here we're sitting and the disaster has just been renewed until the middle of April.
All right. And so one of the issues is that the Command Council allegedly has been keeping minutes, but these are not publicly available. So we're not actually sure what has informed the decisions that have been emanating out of the council. Well, what are some of the other pieces of information that you're hoping to get out of this process, Daniel?
Well, simply put, the reasons and the substantiating evidence on why they're keeping the lockdown in place. I mean, and the problem is we've seen this throughout all lockdown litigation in the past 2 years, the cases that our firm's been involved in and others, that the minister simply refuses to say what informed her decision. And the only time that they were able to provide this was with the case against South African breweries regarding the alcohol ban, because I believe that's the only instance where government actually has data to support their decision. They have data about the amounts of people ending up in ER and, sort of overburdening our public health resources. So that's the one place where they actually did provide evidence. But in all the other cases, with the tobacco case, with the curfew cases, all these other cases, the evidence that they've provided has been rather flimsy. So we hope that we actually get something, but if we don't, and we again get sort of flimsy reasons, then that's what we're going to take to court to say, well, after 2 years, they still have nothing to prove that the state of disaster is necessary to cope with COVID-19 and to effectively protect South Africans.
All right, Daniel, well, this may be a bit beyond the parameters of this discussion, but the government is saying that it wants to codify in legislation certain health protocols, which could include mandatory masks. There's a bit of lack of clarity over that. Do you think that that might be a risk, that some of these more onerous provisions associated with the state of disaster might be made more permanent?
Yes, and I mean, it certainly could happen, and we're still unsure how they'll do this, right? Will it sort of be an occupational health and safety question? So it will sort of come through a labor angle. Will it be in terms of national health legislation, which has its own hurdles, because the national health legislation has, for example, a prohibition on compelling medical treatment. So if government wants to go ahead with its campaign to make sure that vaccines become permanent or mandatory, then they're going to have to amend that part of the legislation which prohibits forced medical treatment at this point. So we're not sure how they're going to approach this, and I think that's the problem government has at this point, is they aren't sure either, or there's a lot of disagreement within the ANC and government on how to approach this sort of post-state of disaster regime, where they can still deal with COVID-19, but they sort of outside of this current framework in terms of the DMA.
So, Daniel, what about public sentiment? What do most ordinary people think about the continuation of the state of disaster?
So it's interesting, and that's the nice thing about having Dear South Africa as a particular client, is they bring a very niche angle to litigation, because they have these sort of ongoing public participation campaigns and opinion polling. Obviously, it has its own limitations, but it gives a good indication of where the broad South African public are. I mean, thousands of people have during the past month indicated that they no longer see the reason why the state of disaster should still be in place. They don't see the reasoning behind why it was extended just this month. So it's really great to have those statistics, and it's awesome to bring those statistics into the court case to help inform the court to come to a just and equitable judgment. So from Dear South Africa's side, their opinion polling has shown that most South Africans feel that we're past this now, we need to move on, and we need to sort of enter the post-pandemic world, and that the government should simply just take the state of disaster and cancel it, if you can put it that way.
So, Daniel, there are several other court cases that are also being launched against the government. Could you tell us briefly what some of those are about?
Yes, so I know that SACA is busy with a court case against the extension of the state of disaster. Solidarity, the trade union, have a case that's actually being heard on the 20th of April, where they're specifically just tackling the extension in Feb of this year. So they're taking on that particular decision, and it would be interesting to see how the court then deals with that. If the one decision is illegitimate in the court's eyes, then what happens to any subsequent extension of the state of disaster? Then it's obviously the court case with AfriForum and DearSA. And we've actually received so many other entities who've sort of come to our firm, and they've said, listen, we want to join this litigation. We really want to take up this fight, because they simply feel that their businesses have been ruined during the past 2 years. For example, the hospitality industry have been, I mean, they're completely on their knees for the past 2 years. So they're quite eager to also get involved in the litigation, and we'll hopefully within the next couple of weeks see how we can include them in the court case.
Daniël Eloff, thank you very much. Let's hand over to you now, our audience. Do you think it's time to end the state of disaster? Leave your thoughts in the comment section below. Also, if you enjoyed this video, you might want to watch this video over here. Also, don't forget to subscribe to our channel. That's linked over here. My name is David Ansara. This is the CRA. Until next time, take care.